Hello, denizens of YouTube, Sister Danger here. This evening, I would like to take a look at an article that I have noticed going across my feed, and it seems to be gaining traction in fandom circles. Cosplay goes to the Supreme Court. The article was presented in a very alarmist way. You'll never be able to cosplay again depending on the results of this ruling. And so I really want to dig into the case that is being discussed in the article and then take a look at what the potential fallout or impact is on fandom and the cosplay industry. One point of note before we begin is that in law, the words design and pattern have specific legal meanings. Typically, in layman's terms, you would think of this as, say, a blueprint or a set of instructions. And I want to be very clear that due to a lack of better terminology as relates to this case, I'm going to be using the word design a lot. I do not mean this word in the legal definition of the word design, being that it is specifically referring to a set of instructions or a plan outline. Rather, when I use the word design, what I am referring to is the graphic or visual imagery, the arrangement of lines or stripes or other such elements that would form a graphical representation of something. One of the reasons that this case is at the Supreme Court currently is because, comparatively speaking, in the United States, we have extremely broad and permissive fashion design laws. Clothing is considered largely an article of utility, and therefore it cannot be copyrighted. The lower courts, however, have been historically extremely divided on where to draw the line between what is considered an article of utility and an artistic work. The case that this article is referring to is Varsity versus Star Athletics, and it really has nothing directly to do with cosplay. It is only that the results of this case could have an impact on the cosplay fandom and industry. For a little bit of background on this case, Varsity holds copyrights on 5 of its cheerleading uniforms, 3 of which are in question. Varsity noticed that Star Athletics was producing uniforms that were almost identical to the ones that they had a copyright on, and so they sued them and took them to court. Star Athletics has challenged this by saying that Varsity does not hold valid copyrights to begin with because cheerleading uniforms are an article of utility and therefore cannot be copyrighted. So the copyrights are invalid, therefore Varsity doesn't have a suit. And that is the very brief summary of the case in question. One thing to note in this case is that articles of utility specifically cannot be copyrighted. You cannot copyright a chair, you cannot copyright a table, or in this case, clothing. The Copyright Act of 1976 protects original works of authorship, which include graphical, pictorial, and sculptural works amongst them. When a two-dimensional graphical or pictorial expression becomes applied to a three-dimensional article of utility, the line becomes very blurred between when that article of utility ceases to be an article of utility and becomes an artistic expression. A success for Varsity here will mean that specific design elements of a cosplay, costuming, or props can in fact be copyrighted. And this brings us to the question of how does this potentially affect fandom and the cosplay industry? The first thing that I want to do is differentiate between types of cosplayers and hopefully take the alert from DEFCON 1 down to DEFCON 4 so that we can just get this out of the way. If you are a hobbyist cosplayer, this is not going to really affect you at all. Making your own costumes, going out into public, going to your local conventions and just walking around and being in that costume is protected under the Fair Use Act. So you're not infringing on any copyrights by doing that. Commercial cosplay, however, is a different story. And what we mean by commercial here is somebody who is being paid or compensated to make an appearance in a cosplay and represent that character. A ruling for Varsity in this case has the potential to affect fandom and cosplay in the areas specifically of commercial cosplay, costuming, and prop design. So if you are a commercial cosplayer, meaning you get paid or compensated to make appearances and do things like photo ops or photo booths, if you are somebody who makes props and sells them in a dealer's room, or for example, if you are a costume maker and you have, say, an online store of some sort, or you also go to dealers' rooms where you sell your costumes or costume pieces to the public, then this could potentially impact you. Specifically, how this would impact you is that you or your hiring entity would have to seek licensing in order to cosplay, make costumes or props in order to avoid the threat of a suit. Now, the reason that a suit is particularly egregious for most people is because a single copyright infringement carries with it a $50,000 penalty. And that is regardless of whether or not there have been any damages to the copyright holder. If fashion design elements can be individually copyrighted, what this means is that a single cosplay could contain within it several copyright infringements, which makes it much riskier for large companies to have professional cosplayers and then come to find that they are falling under a lawsuit for having a certain cosplay that has 10 copyright infringements all inherent within that one costume. There are so many things to know when it comes to copyright law, but one important thing is that the onus of responsibility for collecting on a copyright is on the copyright holder. People infringe on copyrights all the time, and big corporations and businesses basically look at the cost-benefit analysis of going after small potatoes. So some of the anticipated effects that this may have is that there may be a greater push for licensing in commercial cosplay, and this could change the landscape for how small businesses on the internet or in dealers' rooms are permitted to make costumes and props. This could change how large media cons bring in professional cosplayers for their fans to enjoy taking selfies with or doing other such activities. One of the unintended consequences that I'm curious to see whether or not might happen is whether or not we may see a formalization of the professional cosplay industry, where professional cosplayers receive some sort of license or way to identify and separate themselves from a hobbyist cosplayer. And the reason that I would anticipate that this could be a possibility is because at a large scale media convention where there are hundreds of thousands of fans, if a company is in fact concerned about their copyrighted material being portrayed in a way that they don't like, or that another company or even the convention itself making undue profit off of that for which they are not receiving any of their fair cut, then how is the copyright holder supposed to verify whether or not they have been paid in licensing fees, who a particular cosplayer is, if they are professional, if they're not professional, and if they are professional, then have they or whoever has hired them jumped the necessary hoops to be able to have them there and doing what they're doing. This could also have an effect on the photography industry, such that professional photographers or anybody that would be looking to make money off of photographs taken at conventions or otherwise use them for publicity, etc., may also have to receive licensing permissions in order to be on a photography staff or otherwise produce pictures of cosplays that are representations of copyrighted work. Now, of course, if large corporations were to start copywriting their fashion designs and then start going after small businesses, shutting them down and preventing them from making costumes and selling them, that could have the further trickle-down effect straight into fandom, where you suddenly find that the only style of Jedi robe that you can get is sold through Disney directly. So I want to thank you all for listening this evening. Copyright is an extremely convoluted topic, especially as it relates to the fashion industry, where the laws are all over the place and very, very messy. It is something of a pet peeve of mine, the way that artists and con-coms will often freak out at the mere mention of copyright infringement by people who have little to no knowledge of IP law. It was an interesting challenge to try to get this video short and succinct enough that it just didn't bore everybody to sleep with a bunch of legalese. Again, if you like what you see, I do put these videos on my Patreon channel, which I always appreciate patronage there, and I've set up some hopefully interesting reward packages for patrons. Have a good evening, everybody, and I will see you all next time.